Hello, my name is Chris Olson, and this is a presentation about tort law for EDL 850 at Fort Hays State University. So the first thing that we need to do when we consider tort is actually define what tort liability is. Tort liability can be defined as an actionable or civil wrong committed against one person by another. There are a couple different types. These can be deliberate acts or they can be acts involving negligence. So when we're looking at deliberate acts, we are talking about intentional tort. These are deliberate acts committed against another person, and some of the common forms are assault, battery, defamation, false imprisonment, and trespass to personal property. When looking at the other realm of it, acts involving negligence, we're looking at unintentional tort. This is a wrong perpetrated by someone who fails to exercise a degree of care. Most common form of this would be negligence, and this is the one that most of the court cases that I found dealt with. In the first court case that I'm going to discuss, it's Munn versus Hotchkiss, which is a school up in the northeast part of the country. Kara Munn was a 15-year-old who was going on a school field trip abroad to China. During their time there, they went for a hike, and she got bit by a tick and contracted encephalitis, which is, based on my reading, a pretty rare disease, but it's can be very, very devastating as well. This one left her with a neurological damage, and she's no longer able to speak. She was awarded over $40 million in economic and non-economic damages because of the fact that the school never actually warned the families and the students about the risk for this type of a disease. So if something like this was to happen on a school trip in Anne Arundel County Public Schools, I could see a reactive measure very quickly happening in the county of discussion on whether or not we should continue to go out of country for field trips for the schools. Is it worth the educational experience versus the possible harm that could come to the county and to the school district with liability cases if something was to happen? A more proactive measure is to make sure that we ensure that everyone, all the stakeholders, know the possible dangers regarding diseases, the location, the things that they're going to be doing prior to leaving on any type of a field trip, be it 2 blocks down the road from the school to the local park or abroad to another country. So in regards to professional ethics, I think that this is one of those things where we need to make sure that we have policies and steps that should be in place to ensure that all contingencies are considered and planned for accordingly in regards to out-of-country trips, but also in-country trips to local locations as well. The second case is NM versus Anchorage School District. They don't actually provide the name of this student as it is a kindergarten student, but NM was excited because he had made a gift for his mom for Mother's Day and was running to meet his mom after school and slipped and fell. This is something that happens to young kids all the time. My 6-year-old kindergarten student just recently came home with a black eye because he slipped and fell and banged his face into playground equipment. But this time it ended a lot differently for NM. He fell into a clump of pine shrubs and stumps and saplings, penetrated his eye socket, jabbing the frontal lobe, and it's permanent damage at this point in time to his eye and things like that. So they sued the school district for $4.5 million since this route was a common walking ground for the students. Reactive measures, if something like this was to happen at our school, would probably be to quickly go out and examine the rest of the plants, shrubs, trees, everything on campus to see if there's any other possible areas where injuries might be conceivable, even if it's just some accident that might happen. More proactive measure would be to assess the grounds for safe walkways and or possible dangers on a monthly, bi-monthly basis, something like that. It would depend, frequency would depend on where the school is located at within the country, how quickly season turns, what type of weather patterns are happening, things like that. With professional ethics, while it might not often be thought about, because most of us will just walk where we need to walk to get to where we need to go, if a path tends to be a walkway, regardless of whether it's intended or not, it might be worth examining that pathway for safety. If it isn't safe, either change the features of that pathway or else find a way to block off access so that we're making sure that students are only walking on pathways that show to be safe for traversing. The next case is one that actually just finished after about an 8 or 9 year court cycle a couple of weeks ago. Messer versus Boundbrook High School, and specifically the coach, John Sook. Jake Messer was a freshman at the school and was playing his first baseball game when the third base coach, John Sook, told him to slide into the third base because the ball was coming. Messer severely broke his ankle. It required multiple surgeries. He had to give up sports for the rest of his life, essentially. Just tragic thing that can happen at times in sports. But the basis of the court document was that Sook, who at that time had just graduated from college, it was his first year coaching, was Messer too close to the bag when Sook told him to slide? Was Sook responsible for the injury because of being negligible of the possible risk because of how close Messer was to the bag when he was told to slide? So if something like this was to happen, I mean, we know sports can be dangerous. You can get injuries in sports. I know I have had my share of injuries in soccer and other sports as well, but it's part of the risk reward of playing the game. But reactive measure for any sort of coach is to respond to the injured student right away, figure out what's going on, what can we do to help, and then from there possibly discuss improvements for safety of sliding into a base in the case of this court case. More proactive measure, since this case basically hinged on was the student too close to the base to safely slide, was maybe try to create some sort of a safety course for each new coach for a sport in a school district that outlines their sport, possible safety risks, things to consider when you're giving instructions to your students, and things like that. Professional ethics, sports do come with a risk of injury. I've coached since I was a freshman in high school and continue to coach my son's team now in soccer, help out in baseball, and whatever else I can. As a coach, you need to make sure that you're acting in a professional manner. You need to know that, like, yes, students, the kids can get injured playing these things, and you just need to make sure that you kind of try to go over those things with the kids and that you try to avoid putting them into situations that would put them in way of undue risk of injury. The fourth case is Barnett versus Caldwell. This one, Phyllis Caldwell was a teacher in Georgia, and she had to use the restroom during a class period. So she asked another teacher to listen to her class, not physically be in the class, but listen to the class, keep an ear out for them, make sure everything was going okay in her classroom so that she could go to the bathroom. I understand this. Being a teacher, we are basically limited to controlling our bowels to say, hey, this is the time that you're allowed to go use the facilities. So you kind of learn to deal with that schedule sometimes. But sometimes it doesn't always work and you need to go. It's the way of life. The one thing about Caldwell is that she did not let a hall monitor know that she was leaving so that there could be eyes inside the classroom. When using the restroom, two of her students started to engage in horseplay and one fell on top of the other. By falling on top of the student on bottom, actually dislocated their collarbone, and that lacerated a major blood vessel, which eventually caused that student to die. The family sued for the negligence, but the court ruled in favor of the teacher due to the ambiguous language in the district's handbook on terms such as unsupervised, supervised, and supervision. The article that I read was actually written by a lawyer in Georgia that was calling for more stringent definitions in school handbooks to clearly specify what is required for supervision and what being supervised actually means. So reactive measures, if something like this was to happen from an administrative perspective, would probably be you've got to start talking to your staff, your teachers, whole PD about how to properly supervise students, what is acceptable, what is unacceptable, things like that. More proactive measures is to do that at the beginning of the year, beginning of every year. Put safeguards into place for those times where, like, if a teacher does need to leave for this reason or that reason, like I need to use the restroom, there should be some sort of procedure in place so that a teacher can find that coverage to be able to go use the facilities and take care of the business that they need to. Professionally, you need to understand that teachers are assigned 3 legal duties under in loco parentis, and that is to instruct, to supervise, and to provide for the safety of the students. It's the reason why they expect us to be in the classroom with the students at all times, why in the high school environment, middle school environment, they want you out in the halls in between classes when the students are walking around the hallways, why they want you out there at the beginning of the day the end of the day, possibly helping out with bus duty, lunch duty, other things as well. It's so that we can supervise the students, so that we can provide safety to them by making sure that they don't engage in behaviors that could cause harm to themselves or to others around them that might not even be involved in what they're doing. And the last case that I'm talking about is Hoyam versus Manhattan Beach City School District. This one was kind of an interesting one for me because it was a much older case. It happened during the summer of 1974. Michael was a 10-year-old who was attending summer school and decided the one day that he no longer wanted to be in school for the day, so he skipped. He played hooky and left the school property. 4 blocks away from the school, he was struck by a motorcycle, causing severe injury. The school was sued for being derelict in their duty to supervise Michael and ensuring that he did not skip, and that they're contending that the school didn't have the necessary safeguards in place to ensure that Michael could not leave the building. But the court decided that the school acted in good faith with their decisions. However, it was appealed, and the California Supreme Court reversed the decision to determine that Manhattan Beach City School District was negligent. Now, this is kind of an interesting case because you know that kids, especially as they get older, tend to have those students that want to try to skip out on school. They try to play hooky. They decide that they don't want to be there anymore that day and they leave early, accepting what they know the consequences will be if they get caught. So what is the school responsible for, and what is then considered the students on their own in regards to their own responsibility for protecting themselves? A couple of the interesting things that I read in this article, one was from the school district saying holding a school district liable for such an injury to a truant would lead to truant-proof schools, where to avoid liability, schools would basically be required to virtually change students to their desks to keep them from leaving. And there is some truth in that. You can't go ahead and, as I have my reactive measure here, find a way to shut down campus during school hours so that they can only leave during one exit, because then you have evacuation nightmares, and evacuation would not be possible if everything was locked down like that. The other feasibility for a reactive measure is to look at hiring extra staff to monitor halls, but there might not be that money in the budget. And if you start assigning extra duties to teachers, like to make sure that every single possible exit is manned all day during the school day, you might run into risk of quality teachers leaving to go to another district. So there's a lot of things that go into this one that was kind of interesting. Reading through the California Supreme Court decision, one of the other things that I found intriguing about this was in the dissent issue for it, the one judge said, "I cannot say that the next case may not involve a truant who, without anyone's permission or knowledge, deliberately slipped away from school unnoticed, hopped a freight train, and was injured when he fell off a car 4 days later in Duluth, Minnesota. Would the kid be in Duluth, Minnesota, as opposed to in California in school, if the school had prevented him from being truant? But after 4 days, is that the school's responsibility at that point? The question is, when does it end? Like, when is the school's responsibility end, and when does it become the student's responsibility to stay safe? And that's a big question to ask yourselves. So a more proactive measure would be to create guidelines to monitor students and schedules to monitor exits. Establish routines for times that students leave the classroom and actions to take if students do not return in a set amount of time. We know that we as teachers cannot watch the 29 students in a classroom and also pay attention to the one student who's out going to the bathroom, going to the guidance counselor, going to the main office. We just can't do it. But there are ways to establish routines to make sure that you have an idea of where that student is. Number one, make sure that they ask for permission. In the case of my classroom, I tell my students, you have 6 minutes. You have to be back in 6 minutes. If you're not back in 6 minutes, that's when I start to look at contacting administration or one of the hall monitors or something like that, saying, I have a student missing, we need to find the student. So setting up those type of routines, guidelines will help to ensure that you keep track of where your students are. For professional ethics, supervision of students is key to their safety and well-being. While this case file does not state how long Michael was missing at the time of the accident, we know he's 4 blocks away. It is important to realize that if a student has been missing for longer than expected, that we reach out to administration or someone else in the building and help to try to locate that student, because they might just be walking around the hallway because they don't want to come back to class. They might have tried to play hooky and skip. they might have injured themselves somewhere. And if we don't actually recognize the fact that, okay, this kid has been out longer than what's expected, we need to check in on this, we could open ourselves up to liability for that. So that's my presentation on tort. I hope you enjoyed it, and thank you.